Hi, I'm Stephanie and I'm a student in Winnipeg, Manitoba. I have a connection to a story in the book because I work in a restaurant. On May 4th, 1989, the Supreme Court of Canada declared sexual harassment a form of sex discrimination. When Diana Jansen and Tracy Govereau worked at Pharaoh's restaurant in Winnipeg the fall of 1982, they endured outrageous physical and verbal sexual harassment from the cook, Tommy Gramis. Each of the women spoke at different times to the owner-operator, Philip Anastasiadis, about Tommy's behavior, but to no avail. Jansen left the restaurant after only 2 months. Govereau was fired. When both women complained to the Manitoba Human Rights Commission, an adjudicator found the women had been sexually harassed and awarded them money for lost wages and exemplary damages. The case's first appeal reduced the financial award. At its next appearance at the Manitoba Court of Appeal, the judges threw it out altogether, saying sexual harassment is not sexual discrimination. However, on May 4th, 1989, the Supreme Court of Canada upheld the adjudicator's initial decision in favor of Jansen and Govereau, ruling in strong language that sexual harassment is clearly a form of sex discrimination. The court has also delivered a very liberal definition of sexual harassment for Canadian employers and employees. It is used as the benchmark to this day.
Okay, all right. I'm here with Aaron Berg, and he is general counsel, a very senior lawyer with Manitoba Justice here in Winnipeg. And the reason that we're talking to him is he was actually the lawyer involved in the Jansen case that started in 1982 and went all the way to the Supreme Court of Canada in 1989. And so we're really thrilled to be talking to you about this. I'm wondering if you can just tell us generally what your role was in that case.
Okay, my role was just simply to act for the Human Rights Commission, which had decided that it would take the case forward to the Supreme Court after a very disappointing decision at the Court of Appeal level. It was considered an important issue on sexual harassment, a need to clarify what the standards were, what the rules were.
Okay. And at that point, the rules weren't definitive on what was sexual harassment, is that right?
That's right. Sexual harassment had grown out of the concept of sex discrimination. There had been a developing awareness of how behaviors, primarily in the workplace but in other areas as well, could seriously impact on the role primarily of women in that workplace or something. And when I say behaviors, I'm talking primarily about sexual behaviors.
All right. And so this would be where young women, or women as a whole, would be getting sexual attention that they're not interested in, or comments that are made to them?
That's right.
All right. And so now one of the things that when you get to that kind of a senior level that people might not recognize is it turns out you never actually met these women, did you?
No, and that was because I came late to the scene. When they'd first filed their complaints and the complaints had gone forward, the Commission was hiring private counsel on a case-by-case basis. The matter had gone to the Court of Appeal, where the Court of Appeal had tossed the complaints, and at that point I was acting for the Commission as their counsel, and I assumed conduct of the file and going forward.
What was the importance? And these women were relatively young. They were, I think, in their early 20s, as I recall.
That's my understanding.
What was the importance of them actually doing this? Was this considered significant that they would actually come forward?
I think it was, because this was a relatively new area of human rights law, both here and in the United States. There had been a few decisions dealing with this type of behavior in other jurisdictions, but they were at the adjudication level and hence didn't have necessary persuasive power in terms of developing the law in the future. So when these women came forward, what they did was they gave Manitoba an opportunity to address this under its Human Rights Act, as it then was, and then when they ran into difficulties in the Court of Appeal, it gave what turned out to be a wonderful opportunity to clarify the law basically for the entire country.
And it's a definition that 20 years later, 20 years plus later, is still a very solid definition of what is sexual harassment.
That's right. It's pretty much the, well, it's a leading case in the sense that it was the first Supreme Court decision on this that adopted an approach that human rights proponents had been pushing for some time.
And that they hadn't got. So we actually owe a great deal of thanks for Diana Jansen and Tracy Govero for coming forward and making this complaint in the first place.
Yeah, very much so, because the impact on people across the country since 1989 has been profound. And while I anticipate much the same type of decision would have been forthcoming at some point in the future, who knows when in the future.
And the interesting thing for a lot of young women and young men when they're impacted by human rights is I'm sure that lots of times they must look at these cases and think this is well beyond them, that these important decisions have nothing to do with them. And yet presumably we got to tell people it's very important that when their rights are being violated, they've got to come forward.
Yeah, I think so. I think as well, although there's no objective cost factor for complainants who come forward, in the sense that it doesn't cost them any money out of their own pocket. There is a cost to them. There's a psychological cost in putting up with the time to go through, to have the investigation occur, to present their side of the argument to whatever position the respondent may come forward with. And when these processes, as often is the case, take time to resolve, it can be emotionally draining, I would think, on some of them. So I think that it's helpful for them to look at the broad picture and just see how much good they did by complaining when they did and how they did.
Wonderful. I mean, it's wonderful in the sense that they were willing to do that when so many people are fearful of actually coming forward on these kind of issues.
Yes.